Good afternoon. Welcome back to Passionate World Talk Radio Network, a wholly owned subsidiary of Global Media Network. Educate, enlighten, entertain, mindfulness. And this week on Lest We Forget History, we're going to talk about the president and constitutional violations. Will the federal courts contain the president power grabs? It is the Supreme Court to uphold the Constitution, checks and balances on the current administration's efforts to expand their powers beyond what the Constitution allows. And recently, our current president asked the Supreme Court to define what are the limits of his power. The article is written by Devin Ombres, Ombres. If we take a look, or when we take a look at what the current administration has been doing since they took office in January of 2025, the president believes it can act with impunity when it comes to the law and to the U.S. Constitution. In a recent interview, he responded to a question as to whether he had to uphold the Constitution with, "I don't know." In the more than 150 executive orders that he has issued during the first 4 months of his term, he frequently asserts that he's acting under authority granted him by Article 2 of the Constitution. In fact, the Constitution was written and is intended to limit the powers of the presidency, not provide limitless authority as president is contending. The Constitution does not give a president the power to violate the Constitution, create or change congressional statutes, or override U.S. Supreme Court decisions, no matter what the EO say. When a president acts beyond the scope of his constitutional powers, members of his administration or her administration and other departments of the government must step in and stop him, lest the nation face not just a constitutional crisis, but also the dismantling of American democracy. So far, Congress has not lived up to what it should be doing and has failed to serve as a check on executive overreach, perhaps out of fear of political retribution, which he is known for. Thus, it is falling to the courts to robustly fulfill their constitutional role in policing the executive branch when it violates the Constitution and the laws as enacted by Congress. In the first months of this president's administration, at least 39 separate judges appointed by 5 different presidents, including those appointed by the current president, have ruled against his overreaching actions. They have variously issued temporary restraining orders or preliminary injunctions preventing him from, among many other things, ending constitutional birthright citizenship, targeting opponents with political motivated investigation, freezing funding that Congress had approved for projects, and cutting off funding due to political disagreements and to the blue states. However, the few cases that have reached the Supreme Court, the conservative justices appear to be using highly technical and narrow procedural decisions to avoid directly confronting him and his seemingly unconstitutional rulings. such as Kilmer, Abrego, Garcia, and the Alien Enemies Act cases, have resulted in the administration skewing clear rulings to its own ends to frustrate the lower courts. By punting decisions on merits and permitting these unconstitutional actions to continue, the court is providing this president time to consolidate an anti-constitutional regime and take actions that harm America's well-being and undermine our global leadership. The damage being done to our nation will take years to undo, and it also may be irreversible. Until our elective officials stand up to the current administration, efforts to strip its own powers, the courts, and especially the Supreme Court, which must stand up for Americans' rights and the rule of the law. And though there is a right-wing majority on the High Court, the court should still be able to speak with one voice, that the Constitution prevents the president from acting unconstitutionally. The key question here to be answered is, are the president's actions constitutional and legal? And the short answer is no, N-O. The president cannot use the Alien Enemies Act to summarily deport people. His use of EO, invoking the Alien Enemies Act of 1789, and his claim that the AEA grants him the authority to remove people, in this instance, alleged members of the Venezuelan Trendy Agua gang, without due process, appears to be both illegal and unconstitutional. First, the Fifth Amendment was a direct rebuttal to such abuses, as it requires that, quote, no person shall be deprived of life, liberty, or property without due process of law, extending these protections beyond just citizens. Several lower court judges have issued orders prohibiting the removal of anyone under the AEA without due process. Indeed, the Supreme Court recently ruled that the government must provide individuals targeted by this EO the due process right to challenge their removals through the legal process. Though not legally binding, the Declaration of Independence also shines a light on the illegitimacy of our current president's actions. It decried the English king subjecting people in the colonies, quote, a jurisdiction foreign to our Constitution, depriving people in many cases of the benefits of trial by jury and transporting people beyond seas to be tried for pretended offenses. And he's going to celebrate our 250-year history? Really? As a Trump-appointed judge in the Southern District of Texas recently ruled that the president's invocation of the AEA to remove people exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms. To that effect, the AEA, invoked only 3 times in American history, requires, quote, a declared war, or, quote, invasion or predatory incursion by any foreign nation or government for invocation, none of which is present here. In reviewing the invocation of the AEA, a judge appointed by former President Ronald Reagan and George H.W. Bush opined that, quote, an invasion is a military affair, not one of immigration. A recently declassified intelligence memo indicates that Venezuela government is not directing TDA in the U.S., further undermining the president's claims that the AEA was appropriately invoked. So far, he has sent more than 260 individuals, more than 100 of whom the administration says are members of TDA to an El Salvadorian prison without constitutionally required due process. This includes Abrego Garcia, who held a judicial hold on his removal that granted him protection from being deported, despite admitting that Abrego Garcia was removed to an administrative error. The administration has vigorously pushed back against court orders that the government facilitate his return. As a result, one federal judge has already found probable cause to hold the government in criminal contempt of court, defying his orders around AEA removals. A second judge is conducting expedited discovery in the Abrego Garcia case, whether contempt proceedings should proceed. The president cannot legally run for a third term. The current president has openly stated that he would run for a third term and that there are methods for doing so. He's even released his name 2028 merchandise. Regardless of whether he has walked these claims back, the Constitution explicitly forbids him from running for office for a third time. And he'll be too old. We tried it with Reagan, and look what happened with Reagan. The 22nd Amendment was ratified in 1951 to limit presidents to 2 terms after Franklin Delano Roosevelt was elected to a 4th term in 1942. Members of Congress who passed the amendment were unified in its purpose of preventing a dictatorship or some totalitarian form of government from arising. The amendment makes clear that no person shall be elected to the office of the president more than twice. This negates anything our president says and his assertions that he will be permitted to run again because his terms were not executive. BS. Additionally, the 12th Amendment states that no person constitutionally ineligible to the office of president shall be eligible for that of vice president. A clear reading of the Constitution shows that this president could not run for vice president with the intent of the president stepping down upon inauguration because he is constitutionally ineligible.